Thank you very much. Thank you very much, Veronica, and thank you very much, everyone. It's a pleasure to be here today with Professor Piazza and to contribute to this reflection on a topic that is gaining increasing prominence, not only in legal scholarship, but also in a public debate. The relationship between sport and principle of non-discrimination in EU law. Because sport, at its core, is a form of freedom. It might seem like a lesser kind of freedom, just a game, just a pastime, but in truth, it touches the lives of millions of people around the world. It shapes identities, builds communities, and offers a space for expression and for growth. And why should we pay close attention to discrimination in sport? Because discrimination is not just an occasional incident, but it's a risk deeply embedded in the very rules and structures that govern sport. We are used to thinking of sport as an autonomous world, a field regulated by its own rules, institutions, and traditions. However, as sport has become more professionalized, globalized, and economically relevant, the need to reconcile the regulatory autonomy with the fundamental principles of EU law has become even more urgent. At the heart of these legal intersections lies the principle of non-discrimination, which has two distinct but complementary dimensions. First, the protection of individuals, particularly athletes, from discriminatory treatment, especially based on nationality. Second, the regulation of sporting organizations, ensuring that they do not restrict market access or distort competition through anti-competitive practices. Our analysis will proceed in 6 parts. 1, a brief overview of how sport has been incorporated into EU law. Number 2, the economic dimension of sport and the implications for the application of internal market rules. Number 3, the evolution of a principle of non-discrimination in the free movement of athletes, with reference to key case law. Number 4, the autonomy of sporting federations and its limits under EU law. 5, the Super League ruling and the emergence of a structural dimension of non-discrimination. And finally, number 6, some concluding reflections on the future of sport in the legal EU framework. For decades, sport organizations, especially at the international level, have claimed a special status, often described as lex sportiva, as a self-contained and autonomous legal order. This concept is based on the idea that the sports world has unique characteristics, such as a need for internal cohesion, competitive balance, and specialized dispute resolution, which justify autonomy and even exemptions from the rules that apply to other sectors of society. In this view, sporting federations, like UEFA or like EOC, operate with their own internal system of governance and discipline, enforceable through arbitration rather than ordinary courts. These institutions, often described as essential for maintaining fair play and equal competition, ensuring the integrity of competitions, and resolving disputes efficiently and through experts in this field. In legal terms, this has often translated into the idea that sport is governed by private regimes, insulated from the interference of state or international legal systems. In countries like Italy, for example, the sports justice system is seen as parallel and separate from the state judiciary. Athletes and clubs are subject to the rule of their federations as a result of their affiliation, not as ordinary legal subjects. However, this claim to autonomy has frequently come into tension with EU law, especially when the practices of sports bodies impact on the economic freedom of athletes, for example, free movement or employment rights, and on the rights of clubs and organizers to access market. Although Article 165 introduced sport into the treaty in 2009, the EU's interest in sport predates this provision by several decades. Initially, EU institutions engaged with sport through soft law instruments. For example, with the declaration of the European Council of Nice 2000, which emphasized the social, the educational, and cultural dimension of sport, while recognizing its specific nature. Another example is the White Paper on Sport 2007, which called for a European dimension of sport, focusing on issues such as doping, player mobility, and governance. As anticipated, the formal inclusion of sport among the competencies of the European Union occurred relatively late, in 2009. Now, Article 165 of the treaty provides that the Union shall contribute to the promotion of European sporting issues, while taking account of the specific nature of sport, its structures based on voluntary activity, and its social and educational function. This wording underscores a dual approach. On the one hand, it acknowledges the specificity and the social importance of sport, its power to promote inclusion, education, and community development. But on the other hand, it allows for EU coordination and support, particularly in ensuring that sporting practices align with core EU values like equality, freedom of movement, and non-discrimination. However, it was the Court of Justice that played the pivotal role in legally integrating sport into the EU framework, especially through its jurisprudence, beginning in 1970s. The court developed what we might call a dual-track approach. On the one hand, it acknowledged the specificity of sport, recognizing the need for self-regulation and respecting traditions of federative governance. On the other hand, it held that economic activities in the sports sector, such as employment contracts or player transfers or sponsorship deals, fall fully under the scope of EU law, particularly the rules on free movement and competition. The cornerstones of this approach, stated since 2006, is the impossibility to distinguish between purely sporting rules and rules with economic significance as well. All sport rules can, in the abstract, be relevant to the law and therefore must comply with European law. An assessment on the concrete case is always needed. As such, the Court of Justice has rebalanced the relationship between sports autonomy and legal accountability. It does not deny the specificity of sport, but it rejects the idea that sport is exempt from EU law. This evolution is reflected in what legal scholars describe as a de-specialization process, where the application of general EU principles, especially in areas like competition law, internal market freedoms, and judicial review, limits the special status once claimed by the sports system. Let us now turn to the first and most traditional application of the non-discrimination principle in sport, the protection of athletes as workers or service providers within the EU internal market. The story begins with Warrate and Koch, 1974, a case involving professional pacemakers in cycling. In this case, two Dutch cyclists challenged the rule of the International Cycling Union, which required that the pacemakers in motor-paced cycling races be the same nationality as the athletes they were assisting. The Court of Justice held for the first time that European law applies to sport insofar as it constitutes an economic activity. Importantly, the court made it clear that private associations, such as a sports federation, are not exempt from EU law if their rules have economic effects, and that discriminatory rules that restrict access to employment based on nationality are incompatible with the fundamental freedoms of EU. The court established a fundamental principle. When sport constitutes an economic activity, it is subject to EU law. In this case, the court struck down a nationality clause in the rules of International Cycling Union, applying Article 45 of the treaty. Shortly after, in another case, the case Donat versus Montero, 1976, the Court of Justice reaffirmed this view and introduced a crucial clarification. While some nationality requirements may be justified for national teams or competition with symbolic relevance, such exceptions must be interpreted restrictively. In 1995, there is the Bosman case. The Bosman case is undoubtedly the landmark case in this field. Bosman, a Belgian footballer, challenged the transfer rules that prevented him from signing with a new club after his contracts had expired. and the nationality quotas that limited the number of foreign EU players. The court ruled both mechanisms incompatible with the freedom of movement and the principle of non-discrimination. This judgment had a transformative impact. Transfer fee for out-of-contract players within the EU were abolished. Quota system based on nationality were declared unlawful. Athletes were recognized as workers entitled to full mobility rights. The principle of non-discrimination was further refined in another case, the case of Simutenkov in 2003, where a Russian footballer challenged a nationality quota in Spain. Although Simutenkov was not an EU citizen, Russia had a partnership and cooperation agreement with the EU. The court found that once admitted to work in the EU, third country nationals covered by such agreements must enjoy equal treatment as EU nationals with regard to working conditions, including non-discriminatory access to sport-related employment. This shows that the principle of non-discrimination on nationality grounds is now extended beyond EU citizens, provided there is a relevant international agreement in place. To recap, the non-discrimination principle under Article 45 of Treaty prohibits both direct and indirect discrimination based on nationality in sport when it is an economic activity. Private rules, includes those by federations, fall within the scope of EU law when they affect access to employment or services. Exceptions to this principle, such as national team selections, are allowed, but must be narrow, proportionate, and justified. Recent jurisprudence has enhanced protections, extending them also to third country nationals under certain conditions. And to conclude, these rulings have deeply transformed the legal status of sport persons in the EU, affirming their rights as workers and reducing the possibility for federations to exclude or limit participation based on nationality. In all cases, the court has applied a strict test of proportionality, demanding clear justification for any restrictions and preferring less restrictive alternatives where available. The result is the creation of a European labour market for sport, where professional athletes are increasingly treated as ordinary workers, a far cry from the exceptionalism that once characterized the sector. Now, thank you for your attention, and now I leave the floor to my colleague Ippolito.
Thank you, Giulia. Thank you, Elena. Thank you, Veronica. And thank you, everybody who is listening today. I will talk about another kind of discrimination. And first of all, I have to say one thing. It might be strange to talk about discrimination against highly paid professional athletes, or even more against billionaire clubs. But I think that we must never forget that fundamental freedoms guaranteed by European law are at stake. And that in case of And we also have considered that professional sport is only at the top of the movement, but the rules are common for all the movement, all the sporting movement. And in case of athletes, as Giulia was saying, we can't forget that we are talking about workers who can work only under only in the competition under sporting federations. So I'm going to talk about the discrimination that can be carried on by sporting federation. While the principle of free movement that Giulia was speaking about protects individuals, such as athletes, as economic actors, the EU rules on free competition govern the behavior of organization and market structures, for example, sporting federations, ensuring open and non-discriminatory access to economic opportunities. As Giulia said before, sports is relevant for EU law when it comes to economic effects. In a sporting context, this means that governing bodies, we always think, at least in Italy, we always think about football, governing bodies like UEFA or FIFA must not use their regulatory powers to stifle competition or unduly favor certain market participants. They cannot discriminate between athletes based on nationality, but they also cannot discriminate against new market entrants, such as alternative competition organizers, without clear and justified reasons. Because here we have a risk of, as I said before, of a different discrimination that we may call a structural discrimination. Because it's not made on the athletes, but it's made on the system. Because the risk that we have is that sporting federations organize a closed system, limiting the access for other possible competitions. And so a sensitive and recurring issue in European sports law is that of the autonomy of sports federation, especially with regard to the extent and the limits of their power to regulate access to competitions and govern the behavior of affiliated subjects. I think that what I'm saying will be more clear when I'm explaining the main example, the so-called EuroLeague case. The sporting federations usually represent themselves as self-governing bodies, asserting a so-called specificity of sport that also Giulia was talking about. This specificity of sport would justify a kind of immunity from state or supranational intervention. And this view is supported today by the so-called European sport model, which is based on a pyramidal structure that is represented also in the slide. In this structure, we have at the base grassroots and amateur sport and athletes. At the top, we have professional and international competitions. And at the center of this model, we have the sporting federation, which is only one at the European level for each sport, recognized as the regulatory authority empowered to set rules, organize events, and manage international relations. This pyramidal vision is a need. We need to have a federation for a single federation for a sport. Just think about the coherence of the official approval of results. It's difficult to think about two different European champions. Anyway, this happens in other sports like boxing. But we are used to think that we need to have one champion, or at least that a sporting result must have an official approval. Think about athletics. We need to have some rules regulating speed or the height of a jump. But this vision, which is a need I say again, has also some limits and risks, because it also entrenches monopolistic positions, in some cases, lack of transparency in decision making. But a crucial issue that has emerged, especially in recent years, is that this concentration of powers in the hands of sports federation can, because they are at the same time regulatory authorities. As I said before, they set the rules of the game. They are event organizers because they manage the competitions in sports, not only professional competitions. And they are also market participants because they receive broadcasting rights, sponsorships, and merchandising revenues. This conflation of roles raises serious concerns about a conflict of interest, fair market access, and also, in technical terms, an abuse of dominant position. The European Commission and the Court of Justice, in line with EU competition law, require federations to separate these various roles. Anyway, they didn't succeed always to do that. And so that's why, as I said before, in this context, the principle of non-discrimination takes on a structural dimension, because it's in the way itself of how the sport is organized that lies the risk of a discrimination. Since we have a sort of monopoly under the power of sporting federation. And so non-discrimination is not only for athletes or to avoid the favoritism in the competitions, but it can also stand in preventing the establishment of a closed system that automatically excludes valid and innovative alternatives. And as I said before, I'm referring to the so-called EuroLeague case. European Super League, sorry. As I said before, it seems strange to talk about anti-discrimination referring to a company created by billionaire elite football clubs. But as I said before, we cannot forget that we are talking about freedoms in the European space. And we also, and even if we can be used to think about sporting federation as the good subject with that keeps together amateur sport and professional sport, also sporting federation are powers. They are emerging and relevant private powers, even though they also have some public functions, which is a risk too. And so that's why it is so interesting, the EuroLeague case, the Super League case. This case is a ruling, I'm referring to a ruling of the Court of Justice that is really an evolution in EU sports law. It was decided, as you probably know, or if you remember something, in December 2023, it's pretty recent, and the judgment explores not only the rights of individual athletes, but as I said before, the structural impact of regulations on the freedom to organize and operate alternative competitions. Probably the facts are known. A group of elite clubs, football clubs, coming from Spain, UK, Italy, announced plans for a new pan-European competition. UEFA and FIFA, invoking their regulatory powers, threatened sanctions, including bans for players and clubs involved, and refused to grant authorizations, since there is a rule that if you want to establish a new competition, you need to have the authorization from the sport federation. A ban for an athlete. This means for a worker that he cannot work anymore, since a professional athlete is able to do just one thing, and he can do that only under the permission of the sporting federation. This ruling delivered a really transformative message. First of all, the court said that FIFA and UEFA hold a dominant position, possibly even a monopoly, in the organization of professional football in Europe, and that requiring such a prior authorization for any new competition under threat of sanctions may constitute an abuse of dominant position and a restriction on competition. But at the same time, the court recognized the specific characteristics of sport, such as the importance of openness, meritocracy, solidarity, and these specific characteristics must be taken into account. The court also stated that the pyramid structure of European football, where clubs earn their place based on sporting merit, is a legitimate organizing principle. Because the EuroLeague was not, the Super League was not based on this principle. It was based, we say, on invitation. It was a closed club of clubs, because there were obviously economic reasons. Because they thought that audience would have been more interested in competition only of elite clubs. But as I will say at the end, this was not true, fortunately. And also the court said that sporting bodies may establish authorization mechanisms. So the court didn't say that per se an authorization mechanism is illegitimate. It can be legitimate, but this mechanism must be transparent, objective, precise, and non-discriminatory. It means that they must be based on clear, transparent rules. And so, any measure of exclusion or sanction adopted by such bodies can be legitimate, but they must comply with three fundamental requirements. It must not be arbitrary. It must be justified by legitimate sporting objectives. And here comes again the specificity of sport, which is partly recognized by European law and also by the European Court of Justice. And this mechanism must be subject to a judicial review. And this is the problem that Giulia recalled before, that often sporting decisions are not under the control of state judges, but only of sporting federation judges, which is another problem with the monopoly. And also, we are not all law scholars, with the principle of impartiality of a judge. The judge is nominated by the federation, which is often one of the part in the trial. Why is this ruling so important? Because it establishes some principles. Dominant actors, whether public or private, such as the federations, must not abuse their position to stifle diversity and innovation within the sports sector. The right to market access must be guaranteed as an essential component of non-discriminatory competition. And judicial scrutiny must extend to private rules and decisions, particularly when they affect fundamental freedoms or distort the internal market. Here the point is interesting, because EU law doesn't care about the nature of the subject, private or public. What is important are the effects on the internal market. But this case is not the end of the story. because there are some open questions. For example, are similar structure based on invitation in other sports legitimate for European law? Think about Formula One. It's not based on merit, but also some cycling competitions are based on invitation and not only on merit. But at the same time, how far can the European Union go in enforcing openness and meritocracy within highly commercialized and privately governed sports? So how far can we go? Can we prohibit such competitions? Probably not. We have to find a balance. But every commentator said that the Super League had won, but in truth it was not. As I said before, the specificity of sport was recognized and the legitimacy of an authorizational mechanism was recognized. But this mechanism has to be fair. In one word, has to be fair. So we can say at the end that the principle of non-discrimination is no longer limited to individual players. Now it encompasses the structure of the market itself, ensuring, with some limits, that access, opportunity, and governance are consistent with democratic or at least legal standards. Anyway, several challenges remain. How to reconcile federative autonomy with the demands of the internal market, how to regulate, as I was saying, these emerging formats like private leagues or even esports, and how to ensure an inclusive governance, especially in the light of growing commercialization and inequality in sport. But I think that the real conclusion that we can share with Giulia is another one. We all agree that the values of sport, merit, fairness, must be protected. And we all appreciate a sport system based on merit. But the real conclusion is that sport is not outside the law. Sport is under the law, nation and European law. I mean that it's a field where rights, duties, values have to be harmonized. And this is what the court really was trying to say. Super League didn't win and UEFA and FIFA didn't win. It was a sort of partially a political decision in which the court was trying to say we need a balance. We recognize the power of the federation, but it has to be fair. And there is another political issue, if I can conclude, really conclude. We should also consider that sport is, first of all, a social phenomenon. And we can ignore the audience. For professional sport, we cannot ignore the audience and people watching sports, living sports. The true failure of the Super League project was not in the court. It was outside the court, because the project, which has now been partially changed and is still going on, but it has failed because people didn't like it. That's a good thing. That's a good thing. And also because there is a plan. As I said before, we cannot have two different European champions in the same sport. And that's why it is so difficult to establish a new professional competition. not only in Europe. The same thing happened in the most significant example of private league, the NBA, the professional league of American basketball. In the 70s, there were two leagues, but people didn't like that. They became one league, and it has become the most important show in sport all over the world. Thank you.
Thank you.